We have the conclusion arguments come in the Derek Chauvin trial. We do a breakdown on those arguments and the possibility for a conviction. And then we look into the potential rights that have been introduced as a result of the expected result that Chauvin will not be found guilty on all three counts. We look into this story on your April 20th Not So News update. Please like and subscribe if you're looking for daily news content, and dive on in. Starting us off, we're going to be looking at a couple pieces from CNN. They actually did a pretty good job, in my opinion, of looking at the concluding remarks of the Derek Chauvin trial. Specifically, they say the jury will have to rely on recollection and notes during deliberation. One of the interesting pieces during this trial was just the sheer magnitude of witnesses that were called for during the trial. I believe it ended up being about 46 from the prosecution. A lot of those did end up being character witnesses, as well as just a lot of the bystanders during the events, which obviously don't play as much of a role when it comes to the trial. Nonetheless, though, I think it's important to remember that what we have as individuals that can watch the day-to-day events of the trial aren't what jurors would be used to. CNN had the following remarks. Judge Peter Cahill advised the jurors that they will have to rely on their own recollection of the trial with the aid of notes that they were allowed to take, but that no transcript of the trial exists. I cannot give you a trial transcript. No such transcript exists. We count on the jury to rely on its collective memory. You have been allowed to take notes during the trial, and you may take those notes with you into the jury room. You should not consider those notes binding or conclusive, whether they are your notes or those of another juror. The notes should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control, Cahill instructed. This is a common practice during trials and not unique to this case. I think, obviously, like the last part said, this isn't unique, but it's something to remember as we look at the upcoming events surrounding the Derek Chauvin trial. Additionally, I just kind of want to look at what the jurors are actually going to be deliberating about. So what prosecutors must prove and what the jury will deliberate. Following the closing arguments, the jury must deliberate whether or not the prosecution proved beyond a reasonable doubt that former Minneapolis police officer Derek Chauvin is guilty of the three charges. Here's a look at what prosecutors must prove for each charge. Obviously, there's more to it than just these aspects, but this is kind of just CNN's summary of the charges. For the second-degree unintentional murder, prosecutors must prove Chauvin caused George Floyd's deaths while committing an underlying felony. There's no need to prove intent to kill, just intent to act. If convicted, he could face up to 40 years in prison. I personally think this is a bit of an overreach, because the assumption is that there's an underlying felony, and being charged for murder, the murder would be the felony that's being charged, which is why people were kind of confused why they would do second degree but not first. For third degree murder, prosecutors must prove Chauvin committed a reckless act that is eminently dangerous to others with depraved mind. If convicted, he could face up to 25 years in prison. I also think this one's unlikely to stick. I don't know if you could, this one, you know, a little bit more of a case based on the eminently dangerous aspect. I think based on the use of force experts that stated that Chauvin could have gone in with a further use of force, specifically there was the reference to a taser, makes me think that this is unlikely to stick. Finally, there was second-degree manslaughter. Prosecutors must prove Chauvin was culpably negligent and disregarded an awareness of substantial risk of great bodily injury or death. This is the one that I'm a little bit think is a little bit more likely to stick. Specifically, I think with the arguments I've made that Chauvin would be expected to give some type of first aid as a officer, specifically just basic CPR type things. I think there could be a potential that this is the charge that sticks. Obviously, we need to see what the jury finds. Finally, I just want to they give a couple headlines for the different arguments made throughout. I'm just going to read off a couple of them. George Floyd asked for help with his very last breath. Prosecutors say, prosecution says policing is not on trial in this case. George Floyd is not on trial here. Floyd told officers thank you when they initially pulled him out of the car. Chauvin did what he did on purpose and it killed George Floyd. Prosecutor says state proved its case against Chauvin beyond a reasonable doubt. And then they go, Chauvin knew better, he just didn't do better. There were multiple moments in time where things could have gone different. Chauvin acted with indifference towards George Floyd. Crowd that gathered was powerless to help George Floyd. And the prosecuting attorney wraps up closing argument, asking jurors to believe your own eyes. Next, looking at some of the defense's arguments, Chauvin starts with a presumption of innocence. Then defense attorney asks jury to consider the information that Chauvin had before he got to the scene. Specifically, they're mentioning that how there were different codes called out for, you know, how serious an incident is. Chauvin saw other officers struggling with Floyd when he arrived. Only considering the 9:29 timing Chauvin need on Floyd is not proper analysis. Obviously, we need to look at all the events around it. Chauvin's knees on Floyd's neck was not an unauthorized move. And they went to a lunch break. Notably, the defense was somewhat long. It ended up being, I believe, a total of 2.5 hours. Defense resumes. And then finally they mentioned that the jurors ended up nodding, essentially rubbing their eyes and fidgeting, just as a reference to how long it ended up being. Defense attorney asked jury to find Chauvin not guilty on all accounts. And finally, there was a rebuttal that was done by the prosecuting attorney. There is a 46 witness common sense. I personally hate the common sense argument when it comes to stuff like this. You know, whenever we argue things like common sense gun reform, you know, it's common sense why we assume this. It makes me think that you don't actually have a true argument that you're standing on. State only needs to prove Chauvin's action were a substantial causal factor in Floyd's death. In my opinion, this does not seem to line up with the language that was used on those murder counts later on. And unless a jury member actually like writes this down, I'm assuming jury members would be looking at the actual text of what's being prosecuted. Chauvin had all the power while kneeling on Floyd's neck. There's no excuse for police abuse. And prosecution and rebuttal argument, George Floyd is dead because Mr. Chauvin's heart was too small. Obviously, you know, they're hitting at a couple things here. I don't think really, if I'm completely honest, I think both the prosecution and the defense did a very piss poor job, to be completely honest, in this case. But you know, I'm also not a lawyer. All I want to say is, you know, this isn't as sexy as all the movies make court cases out to be. So now we're going to look at some of the emergency measures that have been put in place as a result of the conclusion of the Derek Chauvin trial, and the expected jury deliberation that's probably going to end possibly by the end of this week, probably if not the end of this week, early next week. Governor Tim Walz is marshaling law enforcement to help from other states and asking legislators for more funding as the state juggles the conclusion of the Derek Chauvin trial and tensions over the fatal police shooting of Dante Wright. The extra surge capacity of law enforcement is necessary to be prepared for a verdict in the trial, officials said Monday, after deploying unexpected resources last week to respond to protests in Brooklyn Center where Wright was killed. As the world awaits a verdict in the trial of Derek Chauvin, we need support in our efforts to preserve the First Amendment rights of peaceful protest while protecting public safety, Walz said in a statement. Chauvin faces murder charges in the death of George Floyd last May, which sparked widespread unrest and destruction of buildings. Senate passed $9 million in emergency funding on Monday, and $2.8 million to pay for highway patrol to come from other states, while $6.3 million would be extra costs in Minnesota. Tensions are really high. There's a lot of emotion involved, said Senate Majority Leader Paul Gazelka, sorry for butchering it, who's a Republican from East Gull Lake. But the streets are safer, the buildings are burning, the businesses aren't destroyed. We have to remember, with all the protests that have happened the last year, we can expect there to be a lot of protests, honestly, regardless of what's found in the Derek Chauvin trial. Next, we have Pritzker activates National Guard in Chicago ahead of Chauvin trial verdict. As a request of the city of Chicago, Governor J.B. Pritzker is activating 125 personnel from Illinois National Guard to stand by to support the Chicago Police Department. With a verdict expected in the trial of Derek Chauvin, members of the Guard will deploy to Chicago beginning tomorrow, April 20th, to pre-position and support Chicago Police Department as needed. Soldiers assigned in this mission are from the Illinois National Guard 33rd Military Police Battalion. These individuals are specially trained in riot control operations. At the request of Mayor Lightfoot, I am activating members of the Illinois National Guard to support the city in keeping our community safe. The Governor J.B. Pritzker, it is critical that those who wish to peacefully protest against the systemic racism and injustice that holds back too many of our communities continue to be able to do so. Members of the Guard and the Illinois State Police will support the city of Chicago efforts to protect the rights of the peaceful protesters and keep our families safe. Obviously, I think it's a very unfortunate thing that we're already expecting there to be riots, protests, burning of cities, even before we even have a verdict from the jury. But everyone knows that, you know, if they're not found, if Chauvin's not found guilty on all 3 counts, cities will be burning. And honestly, there was a post by Matt Walsh from the Daily Wire on Twitter who said that, you know, these jurors have an opportunity to, you know, it's almost like they're being held at gunpoint, that their communities are threatened if they don't find a guilty verdict. This is part of why they're supposed to be, you know, not paying attention to the news when it comes to you know, just like the night-to-night activities. That's why they're, you know, put in, you know, separate rooms for just the deliberation period of the jury. But you know, it's, you know, it takes a lot of courage to know that if you find this individual innocent, these communities will be hunting you down as the juror that, you know, said Chauvin was innocent. Additionally, we saw yesterday the comments made by Maxine Waters in her remarks for promoting the fight against racism. She literally said that they should take to the street and fight. And as a result of those, House Minority Leader Kevin McCarthy said Monday that he will introduce a resolution to censure Maxine Waters for saying we've got to get more confrontational and we've got to stay on the street to protest police brutality against Black Americans. McCarthy accused Waters, who chairs the House Financial Services Committee, of inciting violence during a murder trial of former Minneapolis police officer Derek Chauvin, who charged with the murder of George Floyd. This weekend in Minnesota, Maxine Waters broke the law by violating curfew and then incited violence. Speaker Nancy Pelosi is ignoring Waters' behaviors, and that's why I'm introducing a resolution to censure Representative Waters for these dangerous comments, McCarthy announced on Twitter. The one thing I do appreciate is that they're actually just doing a censure vote, which essentially says we don't like what you said. There's actually, you know, no legal ramifications, or no legal like recourse. There's no like personal recourse. There's nothing that actually holds against Maxine Waters. It's just the Senate and Congress saying that this language isn't appropriate. This is what I called for with Trump's language, specifically around election fraud claims and around January 6th, that they should have been doing censure votes rather than impeachment votes. But, you know, once again, that's just my personal opinion. But with that, we're going to be wrapping up. And this year, April 20th, not to news update. Once again, please like and subscribe if you're looking for daily news content, and have a good one.